Hey there, guys. Welcome to another episode of THV Tutorials. My name is Seth, and in today's video, we'll be continuing with our series on company and partnership law. Before you check out this video, be sure you have watched the video on promoters for this to make more sense. Right. So today's topic is going to be about pre-incorporation contracts. Right. Pre-incorporation contracts. I want to look at what they are and the common law, the position of the common law on um, pre-incorporation contracts, and also Ghana's position on such contracts. We'll start right after the intro. See you soon. Welcome back. Very good. Pre-incorporation contracts. What are they? So, a pre-incorporation contract refers to a contract where one party of the contract is the company that is yet to be incorporated. Section 11 of the Companies Act defines a pre-incorporation contract to mean a contract or other transaction purporting to be entered into by a company before the formation of the company, or by a person on behalf of the company before its formation. A pre-incorporation contract can provide for the responsibilities of the subscribers with details such as who will be in charge of the company and who will act as its financial officer. If individuals, promoters, contribute personal resources to their company, such vehicles, office space, equipment, etc., such as, right, very good. A pre-incorporation contract can specify the role of these resources and the terms of compensation before the company is incorporated, right? So what does all of these things mean? So pre-incorporation contract. So we have pre here, right? Pre. So before incorporation contracts before the incorporation of the company. That's basically what pre-incorporation contracts are. Very good. Now they refer to what? A contract, right? Because in every contract there are multiple parties, right? So a contract with two parties. So a contract where one party, one party in the contract is the company yet to be incorporated. Very good, right? So any contract that involves a company that has not yet been incorporated can be said or can be defined as what? A pre-incorporation contract. Actually, it's a pre-incorporation contract, not can be. It is. Very good. Now, Section 11 of the Companies Act. Please bear in mind the Act again. Section 11. Take note of these things. So, Section 11 of the Companies Act defines a pre-incorporation contract to mean a contract or other transaction purporting to be entered into by a company. Right? What does this mean? Purporting to be entered into by the company. The word that you should be focusing on here is what? Guess. Are you purporting? Very good. I'm sure you got it. Purporting. Right. Purporting. What does purporting mean? Right. Purporting is to pretend to do something, right? Or seem to do something, right? So when a company, so they are using this word because companies that are not incorporated technically cannot, enter contracts or transactions. That's why the word purported or purporting is being used in this context, or that's what it means in this context, right? So technically, since a company is not incorporated, or it incorporated is like saying that the company is not formed, right? It cannot technically enter into a transaction, but since they do at the time, the law is making these specifications. Very good. So that's what a pre-incorporation contract is, right? When firms enter into contracts or transactions purportedly before they are formed, right? Because companies are persons, so you cannot form a contract with nothing, right? The company does not yet exist. So what do you mean by that? So these are just technicalities, and the law is being the law as usual. So, right, you get what the pre-incorporation of contract means, right? At this point, is I've stressed on it. Very good. Now, so continuing with the plain English. Now, a incorporation contract can provide for the responsibilities of the subscribers with details such as who will be in charge of the company and who will act as the. We've spoken about all these things already in the promoters video. So now let's just continue. Pre-incorporation contracts binding on a company once it is incorporated, right? That's a good question, because if I'm a company, there are even projects like this, you're not incorporated. So if we enter into a deal with you, should they be binding? Right? Imagine that because currently, you see, the difference here is that it's a matter of formality, right? A company can exist, you can be going about and doing your left and right, but if you're not incorporated, the law does not recognize you as a company, right? In the eyes of the law, you have not been formed. I get what I'm saying. So you don't exist, because companies have to be formed and registered because they are considered to be persons. They are legal persons, right? So if you're not incorporated, technically speaking, you don't exist. So the law is saying that when companies make deals before they exist, when they come into existence, do such contracts that they made when they did not exist, those contracts, are they binding, or should they be binding on the company? Should the company be obliged to fulfill their obligations or entitled to their rights in such contracts? Let's see what the common law has to say about that. So the common law position on whether pre-incorporation contracts are binding is that such contracts are not binding on a company, right? That's heartbreaking, right? The company law position on the matter is that what? Like what? Such contracts are not binding on the company. The common law just broke my heart. Very good. So they are not binding, right? Now the company cannot ratify such contracts when they are incorporated. The reason is the companies have not yet been formed and have no legal standing. So the common law is very strict on this, right? The company cannot ratify those contracts when they are incorporated, right? So when you're when you start existing, you cannot do anything about those contracts. Why? Because you didn't exist, and the common law is very strict. It doesn't care how you feel, right? So the reason is the companies have already read that. Very good. Now, common law is based on precedent. That means judgments made in the past. So this position was applied in the case of Kellner versus Baxter. And some numbers, don't memorize that. So on 27th January 1886, certain persons signed an agreement for the purchase of stocks on behalf of a hotel company that they were about to form. Payment was to be effected on 28 January 1886. The company was incorporated in February 1886. It used that was supplied, but it used the supplies that it received, but later went into liquidation before it could pay. The company was sued, and the court held that the company was not in a position to ratify the said contract because it did not exist at the time the contract was made. The court observed that a company cannot have an agent before it comes into existence, right? So ratification by the company when formed is legally impossible. Are you getting it? Good. So I made this point in the promoters video, right? So let's check that out. But basically, that's what we've been saying. The company is only recognized as a company, as a legal person in the eyes of the law, when it becomes formed or incorporated, right? So if you enter into a deal with unincorporated companies, you cannot ratify them. You cannot do anything when the deal goes bad, or when you get cheated, Right, so that's the stance of the common law. Right. So here's another case: newborn versus Sensolid Limited. Right. In this case, a company was about to be formed and called Leopold Newborn London Limited. Its directors and members were Leopold Newborn and H. Newborn. There was a contract under which the company was to purchase tinned ham from a supplier, Sensolid. Right. So the Sensolid that is at the top. Sensolid Limited is the supplier. The contract was signed in the name of the company with L. Newborn's initials signed at the bottom, but not on behalf of the company or its agents. The court held that the company was not liable because it was not in existence. It further held that Leopold Newborn was not liable because he did not purport to act on the company's behalf as an agent. The reasoning behind the decision was that Leopold Newborn, instead of contracting on behalf of the company, had caused the contract to be entered into purportedly by the company itself. Therefore, there was no contract at all, and neither the company nor Leopold Newborn were liable. Right. So let's break this down. Right. So in the business of what, directors and members were Newborn brothers, whatever. Right. Now there's a contract. Very good. So this is where the point is, right? In this case, a company was about to be formed, right? So the company that they were going to form was to be called what? Leopold Newborn London Limited. Isn't it? So this was supposed to be the name of the company, right? You know, the name of the owner of one. So Leopold was a director, right? His directors and members, and then H. Newborn, whoever that is, would have been the member of a company. Right. Now, this company, this Leopold Newborn company, entered a contract with the supplier, and everything was finalized, right? But when Leopold was going to sign the contract, he signed it. He signed it in the name of the company, right? He signed it in the name of the company, right? So another key takeaway here is in the name of the company. So since he signed it in the name of the company, with what L Newborn's initials signed at the bottom, so he used the L Newborn, so he was signing the name of the company, right? Now this transaction took place in what? Or the time was not given, but basically speaking, at that point in time, the company was not incorporated, right? So the supplier took this protocol that it's not giving my money, blah 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 blah, and the company and the court held that what, the company did not exist, right? It was signed in the name of the company, so neither the Leopold nor his company are liable. Very good. If you don't understand, let me know in the comment section. I'll do something about it. Right. So that's the common law position. Now, what is Ghana's position? Right. What is Ghana? Like Ghanaians, what's our position on this? Right. Under Act 992. Now, Ghana's position is different from the company law position and gives room for a company to ratify pre-incorporation contracts. Right. So Ghanaians said that we don't respect anything. So we'll change it. Right. Very good. God bless Ghana. Right. So Ghana is saying that there is room, or there are circumstances under which a company can ratify such contracts. Right. So section 11.1, right? So please be paying attention. The sections, so you section 11, right? So be paying attention to this one. Section 11.1 of the Companies Act provides that a pre-incorporation contract may be ratified by a company writing 18 months after the formation of the company, right? So there's a time frame here, right? So the Companies Act, Section 11(1) of is saying that these pre-incorporation contracts can be ratified or can be revived by the company within, I think it should be within 18 months after the formation of the company. So after incorporation, the company has 18 months to ratify such contracts, right? Therefore, if the 18 months period passes, a company cannot ratify a pre-incorporation contract, right? So in Ghana, you have to do it within that window of 18 months, right after you have been incorporated. If you wait after that period, you cannot ratify those contracts, right? So furthermore, on the Ghanaian position, Section 11 2 of the Companies Act provides that on ratification of a pre-incorporation contract, the company shall become bound by and entitled to the benefit of the contract or that transaction as if the company had been in existence at the date of the contract or other transaction and had been party to the contract or other transaction. Right. So the Companies Act is making the point again that when the company ratifies the transaction, they'll be what? Bound by it, and they'll be entitled to the benefit of the contract or the transaction. And it will be as if when they made that contract, when they entered into that contract before the incorporation, they're incorporated. So to ignore the fact that they were not incorporated, so everything will be like as if the company was already registered was already formed when they entered into that contract. Very good. Right now, please again, if you are trying to state this further point, you have to bring this. Right. You have, oh, right. You have to mention them, state them. Right. Now, Section 11(3) of the Companies Act provides that prior to a company ratifying a pre-incorporation contract, the person who purported to act in the name or on behalf of the company is in the absence of any express agreement to the contrary. Right. Let me take my time. Right. So Section 11(3) of the Companies Act is saying that before the company revives a pre-incorporation contract, the person who purported to act, right? So this was again purported. So the person who acted in the name of the company in the absence is in the absence of any express agreement to the contrary, personally bound by the contract or other transaction, and is entitled to the benefit of the contract or other transaction. So what we can do here is that you see that they are using the word purported here again. So isn't that the person who spearheaded that pre-incorporation contract, right? On behalf of the company, is also entitled to and also bound to that contract that is going to be ratified. I estimate. So it's not like when a company, so any benefits or any interest that individual had in the contract, will also stand. I hope you are getting that. So here, so you get that point. The English here is a bit it's poorly constructed. Well, bear with me. Let's work with it. Right. So personally bound by the contract or other transaction, and is entitled to the benefit of the contract or other transaction. I think so. You have a saying that the person who helped to cook the food will surely eat some, right? And that's what they are saying here, that it's not like the company will GI and be like, Charlie, we are big boys now, we won't give you some, right? The law says that whoever took part in those agreements should be entitled to the rights and also be bound by the obligations and duties in that contract. Right. Thank you very much for watching. Please don't forget to like and subscribe, and kindly drop a like, hit the subscribe button, follow THU tutorials, and we'll do our best for you. And we got shout outs to all our current 387 subscribers. Really appreciate all of you guys, and so much love from this side. Thank you very much for watching. I'll see you in the next video.